Good morning, everyone. Welcome to our HSQ webinar. We are glad to have many esteemed attendees with us today for our webinar on will and probate. Before we kickstart this session, please be informed that all the participants will be muted, and if there are any questions, please leave your question in the chat box and we will discuss them during the Q&A sessions later. So now, please allow me to introduce our speaker, Ms. Siang, who has recently been promoted as our partner in HSQ. So please join me to welcome our speaker, Ms. Siang.
Thanks, Yanni. Hi, good morning, everyone. I'm Siang. I'll be the speaker today. So thanks, everyone, for joining this session this morning. So let's start with my sharing today on will and probate. These are some of the key points that I'm going to share in this talk today. There will be importance of having a will. What is a valid and legal will? The formalities, the problems of not having a will, the administration of assets, the possible complications and challenges, transmission and transfer for the immovable property. Those administration of assets, transmission and transfer will be on the brief procedures that I'm going to share later on. Let's see what is a will. A will is a declaration of person's intention concerning the distribution and devolution of the assets and properties which a person would like to carry out into effect after his death. Sorry, a moment, please. Okay. Slides. The next question is, why do I need a will? I believe all of us has heard about will, and everyone is familiar the importance of will, the need of having a will. But rather weird is that most of us don't know, for whatever reasons, we don't really draft a will for ourselves. Hey, can I have a raise of hands? See how many of you has not been writing your will on yourself? I won't be able to see you guys in the screens here, and most of you are not on video. So let's see why is a need for all of us to have a will, and the importance and benefits of having a will. If you can see the importance of having a will, firstly, you can distribute your assets to your intended beneficiaries according to your wishes. You can choose the executor and trustee you trust. You can choose the guardian of your children if your children are minor. You can create a testamentary trust in your will. And the administration estates process and the inheritance process will be easier, faster, and straightforward process if someone passed away with a will. In the later slides, I will share with you what are the procedures in getting a grant of probate and grant of letters of administration. The process of getting a grant of probate, meaning someone's passed away with a will, and someone passed away without a will, there is relatively a big difference in terms of the time cost. In terms of the hassles that you bring to beneficiaries, there is a huge difference. And most importantly, if we are having a will, it can actually minimize potential family disputes. To be a valid and legal will, these are the applicable laws in Malaysia. There will be Wills Act 1959, Probate and Administration Act 1959, Distribution Act 1958, and Small Estates Distribution Act 1955. Do take note that if there's any Muslim friends, if you are participating in this seminar, all our wills, it does not, all these acts and the wills of a person professing religions of Islam are not applicable. Our Muslim friends, the devolution and the dissipation of assets are governed by the division of estates under their Islamic law. Here, let's look at the formalities of a will. What should be included in a will? So the formalities are all governed under the Wills Act, Probate Administration Act. So in a will, we need to write down the particulars of the testator clearly as to the name, IC, address, and in your will, you can appoint your executor or your trustee. Executor is a must as is a mandatory requirement under the will. And in a will, we do have our contents. It can be the testator can leave your intention, your wishes, the assets you want to distribute to your intended beneficiaries. And beneficiaries that you can decide that you wish to give your assets to. A will has to be witnessed by at least 2 witnesses in order to be valid will, and you have to date your will. Testator means a maker of the will who can actually make will. Every person of sound mind with an age of majority, meaning above 18 years old, as long as he is sound mind, he can make a will. Another one, the formalities for the appointment of executor. Executor is a person appointed under the will in order to administer the estate of the testator, to carry out the wishes and requests of the testator in accordance with the will of the testator. So testator, you may want to, there is maximum 4 individual testator can be appointed under the will, and appointment of alternative executor can be stated in the will. Appointment of alternative executor is actually a good way to state it in the will, because in the event your appointed executor predeceases the testator, an alternative executor can be in place without a need to do a fresh will. So the beneficiary named in the will can be appointed as the executor. So you may want to choose your executor from the pool of beneficiaries. You may have four beneficiaries, 3 beneficiaries in the will. You may want to find those that you are trusted to be your executor. If the beneficiary involve minor, infant, or life interest under the will, administration shall be granted to a trust corporation or at least 2 individuals as executor. Of executor. Executor will be entitled to a commission, but is discretionary upon your application. So under the Probate Administration Act, executor is allowed to have a commission for not exceeding 5% on the value of the assets collected. But however, this one you may want to put on an application to court during the application for grant of. What other things can be disposed by a will? These are the things that you can dispose under the will. It will be your immovable properties, your house, your land. It can be your movable properties, your cash, your money in your bank's accounts, your shares in the companies, your partnership interests, your vehicles, your movable property, your movable furniture, jewelry, or anything that you can think of. It is valuable. You may want to pass to your beneficiaries. You can put under your movable properties. And the emerging trend I see that people may want to put in their digital assets. Digital assets could be those your accounts in Facebook, Instagram, your other accounts that you may want your beneficiaries to know, some things that you may want to disclose to the public after your death. So that digital assets can also be included in your will. But there is no specific law governing digital assets in Malaysia as of now. And some testator may want to remain his privacy upon his death, so it's ultimately the testator choice. And lastly is the residuary clause in a will. Residuary estates clause is very important, and it has to be in a will because residuary clause serve as a catch-all provision. So sometimes when we drafted the will and thereafter we may acquire other properties, be it movable or immovable or some other valuable assets. So that residuary clause is basically cater for all other assets which is not included in your will. So yeah. This residuary clause is important as you don't have to keep changing your will. You don't have to keep adding your will if you are acquiring more assets. Unless you intend to change your beneficiaries after acquiring new assets, then you may want to amend your will by adding a codicil or making a fresh will. What are the things that cannot be disposed by will? These are the 2 things, EPF and your insurance policies. In Malaysia, when we do have EPF, Employee Provident Fund, it is governed under the Employee Provident Fund Act. If there is a nomination under EPF and insurance policies, if you can see, most of us, we actually put in a beneficiary or nominee under our EPF and insurance policy. If there is an inconsistency between the nomination under your EPF insurance policy with your will, a statutory nomination will prevail, meaning those beneficiaries named in your EPF and insurance policy will prevail over those beneficiaries named in your will. So make sure you have do it consistent between the EPF, insurance policy, and will. The conditional gift by will. Conditions imposed by testator in a will. Testator has rights to impose some conditions precedence, so they may want the beneficiary or the donee, the recipients of the gift, carry out or fulfill certain conditions in the will before they are entitled to receive the gift. However, those conditions cannot be against public policy, illegal, uncertain, or impossible to satisfy. The common example when people are imposing some conditions precedence in a gift, that is rather normal in the current circumstances now. As an example, the testator may want to impose some conditions if, let's say, he wants to give a gift to the nephew or niece. He may want to put in a condition that the niece has to achieve certain milestone. The milestone can be he has to be graduated from a university with a degree, then the niece will be entitled to a 50,000 ringgit from my estates. So if, let's say, these kind of conditions cannot be fulfilled by the niece at the end of the day, those estates which they cannot be inherited, this gift becomes a conditional gift. It cannot be inherited by the niece, then it will pass to becomes a residuary assets. Residuary assets will have a clause to be distributed to the other beneficiaries according to the will. Testamentary trust. A testamentary trust is created under a will and it will take effect upon the death of the testator. Testamentary trust, the creation is basically to provide for a manner of distribution of assets and also to preserve the assets of the testator. It can be fixed, it can be discretionary. What are the benefits in creating a testamentary trust? In a testamentary trust, usually it needs a trustee or a trust corporation which has a discretion in handling the assets. So it is a way in preservation of assets and wealth of the testator, and there is a prevention of assets being dissipated prematurely. How does this testamentary trust work? In the usual circumstances which we have come across, the most common practice is when a testator, a husband or a wife, they may want to bequeath all their assets to the wife, and 100%, let's say, or they may want to bequeath all their assets to the wife and the children equally. So these are the common practice, and the common will has been drafted in most of the Malaysians. So they are relatively simple. But testamentary trust is ideal to protect the assets being dissipated to the beneficiary. If, let's say, the beneficiary are still minor and they might not be financially savvy. Reason to say so is, let's say I have a few properties and a few houses, it will be vested in the trustee for the benefit of the beneficiary. When the beneficiary attains the age of majority, meaning 18 years old, the assets will be passed to the beneficiary in a lump sum basis, meaning all the houses, all the assets, the cash, the money will all go to the beneficiary on lump sum basis. There is a risk where the testator may anticipate the beneficiary who is not capable in managing the assets by himself. He may just utilize the monies to do things, and the monies will be like dissipated or wasted. So that's where a creation of a trust is important, when you may want to set certain milestone, or you may want to set certain trust when the beneficiary attains certain age or attains certain milestone. i.e., I can do it in a way that I may want to bequeath 100,000 to my beneficiary upon he attending the age of 18 years old. I may also want to create a testamentary trust that my son can inherit my property when he attains his age of 30 years old. So that is a way that we can actually planning for our assets that will not be wasted, and we can actually planning for our assets. We are in a way that we can actually help our beneficiary to manage and to assist them in managing the assets, which assets will be in a lump sum basis, where the beneficiary which is not ready or is not financially savvy in managing the assets. Testamentary trust, I see some questions from the pool that were asking about the will and trust. How can it use as a succession planning in Malaysia? I will discuss that in after my presentation on that question. So let's determine who are the beneficiaries. Beneficiaries are individuals with capacity to inherit, and individuals who have no capacity to inherit. If let's say the beneficiary predeceases the testator, or the beneficiary be the attesting witness, or the husband and wife attesting witness cannot inherit. The husband and wife, if let's say you are naming a wife as the beneficiary, the wife cannot witness your will. So it comes to the mode of execution later on. In executing a will, testator will sign the will at the foot or at the end of the will. The signing by the testator shall be in the presence of 2 or more witnesses present at the same time. The practice is at least with 2 witnesses. So these 2 witnesses will sign in the presence of, after the testator sign the will, and they will sign simultaneously at the presence of the witnesses. But do take note that executors and beneficiaries cannot be the witness of the will, but beneficiaries can be executors and trustee of the will. So as I said earlier, the executors usually will be someone that the testator trusts, so that the beneficiaries usually we can choose our executors from the pool of beneficiaries. Other things to take note. It is not a requirement to initial each and every page of the will, but it is a good practice to follow. Basically, to initial each and every page is not a mandatory requirement, but in Malaysia, we used to have this good practice just to ensure that there will not be any unforeseen circumstances when the will has been modified, changes. So with the initial is a good practice to safeguard all these unnecessary and unwanted circumstances. And a will need not to be stamped in order to be valid. And a will can be amended by way of codicil or making a fresh will. And a will will only come into effect upon the death of the testator. Where to keep your will? You have to store your will in a secure place. In my opinion, if your will is drafted by your solicitors, your will writing service provider, your will writing company, you can let them to store a copy of your will, just in case in the event there is any loss of misplace of your will. And if you have to appoint your executor, so it's better to let your executor know where they will store your will. So at least he will be able to locate. Executor is very important because he has the duty to administer your assets. So it's always good to communicate with your executor and ask your executor permission whether he is willingly and he is on voluntary basis he wanted to administer your assets before you place the executor under your will. And some of the beneficiaries, if your beneficiaries are purely your children and you are bequeathed 100% to your children, you may also want to let your children know where they will store your will. But it's ultimately the testator choice whether they want to keep it privacy and keep it private and confidential until his demise. A will can be revoked by way of destroying the current will or writing a new will. A will will be revoked automatically by marriage. So unless if the will is made in contemplation of marriage, if you have done your will now and you got married later on, the will will be automatically revoked. So you have to do a fresh will in order to carry out your wishes. Next, what are the problems of not having a will? Let's see. These are all the anticipating problems when I can foresee if we die without leaving a valid will. So the first thing that come to us is who will be the administrator. Since we don't have an executor, we don't have someone that we trust and that has been appointed under the will. So who will administer the estates after the death? And the beneficiaries will be having a difficulties because they have to locate and have to find all your assets, being immovable, movable. If you have a title at house, also they have to find all the titles, all the cash in the bank's account. So, and the beneficiaries will be facing the sureties, two sureties for the administration bond. The process that we will discuss later in the grant of letters of administration required by the court. And the assets is to be distributed according to the Distribution Act 1958. And the court will appoint a guardian for the minor kids if, let's say, there's no surviving parents or grandparents. Problem of not having a will, there will definitely has a risk of creating potential family disputes. And lastly, the longer process in getting grant of letters of administration and also applications for distribution order. Since it is a longer process, it's totally a different court applications and there will be more time consuming and more cost incurred. Let's see. Administration of assets are two parts. Testacy, meaning with will, that will go through the process for grant of probate. Intestacy, meaning someone dies without leaving a will, they will go through the process for grant of letters of administration. So a very brief diagram showing the differences in the process of getting a grant of probate and grant of LA. When a deceased passes away, if let's say is with will, that will go on testacy. Process is quite straightforward. Executor will have to prove the will. So executor will have to appoint a lawyer and bring over to get a grant of probate. For intestacy, is without will, person interested in the assets can apply. Any person interested in the assets that will be governed under the Distribution Act, they can be your siblings, your spouse, your children, your parents, any person who are interested in the assets, they can apply for the grant of LA. And the court to grant administration to whom it thinks fit is the court's discretion. Administration bond is required if, let's say, the assets is above 50,000, unless the application was made to dispense with this requirement. Once we get the grant of LA, there is another separate applications for distribution. Distribution order will be required because in order to carry out the transmission and transfer of properties, they were required by the land office. Testacy, this has been explained. The process in getting a grant of probate, these are the procedural things like you have to file your OS, affidavit in support, appointment of solicitors, and affidavit of witnesses. So your witnesses is also important. The two witnesses will have to file an affidavit verifying that they have actually seen, they have actually verified that the testator has made the will in the presence of the witnesses. This is the process for intestacy when a grant of letters of administrations process is slightly lengthy because it's still the same OS with affidavit, appointment of solicitors, but you will need to get those renunciations that all the beneficiaries that have no issues with the appointment of this administrator. And there are other administration of oath. This is for the administrator to give an oath that he will administer the estates faithfully. Administration bond, that's why I say, as a surety, it is a surety kind of bond for estates which is exceeding 50,000, unless an application has been put forward to dispense with these applications. And thereafter is a totally separate applications to get a distribution order. Distribution will be done by way of Distribution Act 1958. When it comes to successions to intestacy case, the person who are entitled to the assets will be based on the law of the country. So in Malaysia, there will be under Section 6 of the Distribution Act. These are the priorities. They will go to spouse, children, parents, siblings, grandparents, uncle and aunts, great-grandparents, great-grand-uncles, and great-grand-aunts. So let's see. A brief one, if let's say someone has gone through the grant of LA, they are not leaving a will. So these are the distribution under the law of Malaysia. If you are leaving a spouse, a child, and a parents, your child will get half, and the spouse and parents will get quarter of the portion. If you are leaving a spouse, a parents without a child, your spouse and your parents will get half. If you are leaving a spouse, a child, and no parents, the child is getting 2/3 and the spouse is getting 1/3. A child is always having a bigger portion. If you are having a child, a parent, and no spouse, the child is getting 2/3 and the parents is getting 1/3. If you are leaving only spouse, then your spouse will get the whole estate. If you are leaving only child, the child will get the whole estate. If you are leaving only parents, then parents will get the whole estate. So the next thing, if there is no spouse, no child, no parents, the following persons are entitled in priority. There will be brothers and sisters, our siblings, grandparents, uncle and aunts, great-grandparents, great-uncles and aunts, and lastly is if there is none, then it goes back to government. That's why it's important to have a will. So another thing is the small estate distribution. A lot of us may not aware that there is this small estate distribution act exists in Malaysia. This is to govern estates of the deceased when it consists wholly or partially property with the total value not exceeding 2 million. So if let's say the deceased have left an assets or not exceeding the total amount of 2 million, actually the beneficiaries can go by way of small estate distributions. They can put in applications in the relevant land office where the deceased immovable property is located. And these things can be done by the beneficiaries themselves without going through solicitors or lawyers. If there are movable properties located in several states, the beneficiary may choose one of the relevant district or states of the land office to submit its applications. So the land office of the very first applications is submitted will have the exclusive jurisdictions. Small estate distribution is relatively simple. The process is also simple. The beneficiaries can manage the applications by themselves. However, if the beneficiary is facing any difficulty, they may always choose to engage the services of lawyer if they wish to. Though take note, small estates distributions is only cater for the estates of the deceased, not exceeding 2 million in total value. What are the possible complications and challenges? Although with a will, there are possible complications and challenges if there is any issues in respect of the capacity of the testamentary capacity, if there are any issues or challenge raised by the beneficiaries on undue influence, suspicious circumstances, forgery or fraud. As discussed, everyone can make will as long as you are attain your age of majority. As long as you are sound mind, you are entitled to write will, you are entitled to make a will. But there are situations where a person will be challenged the validity of the will. So if let's say it has been challenged, the person challenging the validity of the will bears the burden of proving the testamentary capacity. So one thing very important here is that the contents of the will has to be read to the testator, and the testator has to understand the content, the effect, and the extent of the disposal of the assets. And the witness is also important. The witness has to really, in the presence of the testator, and sign after the testator has executing the will. So there are other situations like undue influence. So something the person alleging undue influence has to bear the burden of proving. There are other circumstances like suspicious circumstances when the will doesn't really spell out the intention and the wishes of the testator. So testator is always good to seek independent legal advice. As I said, they may wish to go to the person that they trust, to go to some professionals, independent legal advisors to get the will drafted. So in order to meet and fulfill all the formalities and requirements to constitute and execute a valid will. forgery and fraud. This kind of allegation sometimes happens when there are situations in the existence of two wills. Expert of handwriting may be evidence of handwriting expert may be required. Why there are two wills in existence? Usually when we have made our will, let's say if I have write my will at the age of 30. So after all, I acquire various properties and I have made more cash, that I have changes my mind. I would like to change my beneficiary. So I would like to make a fresh will. So in my will, usually the very first paragraph, we need to state that we revoke all our former and previous will. So we will date our will, the current date of our will. So the later will always prevail over the previous will. So, but still, if there is this possible complications that could be raised for person alleging the forgery on the signature of the testator. Yeah, last thing on the transmission and transfer. What after I got my grant of probate and grant of LA, what other procedures to get my immovable property to be transferred to my beneficiaries? So here you can see grant of probate with will and grant of LA is without will. The process the process are relatively the same. We will first go through a transmission to the executor. This is to be applied in land office that are prescribed form by the land office. However, in Malaysia, different states that have a different prescribed forms for the transmission. So we have to follow the relevant land office where the immovable property is situated. So usually the title will be registered under the name of executor. If without a will, the title has to be registered under the name of administrator. And thereafter, with the title, we will do a form of transfer. This is the standard form 14A prescribed under the National Land Code. We will transfer the property to the beneficiaries in accordance with the will or in accordance with the distribution order. So thereafter, the title will be registered under the name of the beneficiaries. So both processes are quite similar, unless in certain states like Selangor, the transmission, if you have a will, once you get your grant of probate, the transmission and transfer can be submitted together. So it actually cut the process short. We can submit the transmission and transfer together. Yeah, but it does not apply to other states. Yeah. So that's the end of my session and sharing. So let's go to the Q&A session.
Thank you, Shangli, for the enlightening sharing. I'm sure it is very helpful to many, especially our attendees today. So now we will proceed to Q&A sessions. I would like to share a list of questions that have been posted by the attendees before the webinar. Okay, so the first question is posted by Trish Young. Are wills written in Singapore for properties in Malaysia recognized?
Oh, all right. My answer is yes. Basically, there are some procedures to be complied with in order for a will written in Singapore to be recognized in Malaysia. And in fact, it is not really important that the will is written in anywhere. The most important is where you are domiciled and what is the convenient forum for your beneficiaries to get a grant of probate. So to Trish, I think your questions here, you may probably, assuming if you are a Singaporean, the convenient forum for you to get a grant of probate is in Singapore. So once you get a grant of probate in the courts of Singapore, then you may need to appoint a lawyer in Malaysia and get it resealed. Resealing is a process when you get a seal from the High Court in order to verify the probate. So when you get a resale process, the grant of probate which is granted in Singapore will have the same effect as if it is granted in the Court of Malaysia. So my answer to this question is yes, as long as you get it resale thereafter. And in fact, it's all in the Commonwealth countries. If let's say you've done your will, you get a grant of probate in the Commonwealth countries, you can get it resale in Malaysia, it will be recognized.
Okay, so let's come to question 2, posted by Trico from Labuan. How to use the will and trust as a combination of succession planning in Malaysia? Will you have any case studies?
This is an interesting question. Yeah, I saw these questions yesterday, so I find this question is very interesting. And that's why I have explained, I have actually in my earlier slides, we talked about testamentary trust. But I think the trust mentioned here could be on a wider and broader perspective. Yeah, my point of view is that I don't really have any case studies in hand to discuss about this topic, but I have my personal point of view on the will and trust. So basically, will for a succession planning in Malaysia, when we talk about creation of trust, it has been an emerging trend in Malaysia when most of the people, we are aware that we don't really want to bequeath 100% of all our assets to our children. As commonly practiced in Malaysia, we used to bequeath all our assets to Malaysia, to our siblings, to our spouse, to our children. But there is a risk that they may actually dissipate the assets, or there is a rest when they are not financially capable in managing the assets. So the most common scenario that I can think of is the testator will understand their beneficiary very well. So they will retain some control as if they want their beneficiaries to manage the assets instead of giving all to them and let them just decide whatever they want to do. So the best way that to my point of view, creation of a trust is actually a good way. It can be in fixed trust or discretionary trust. I can give some examples here. If let's say I would like to make a will, I have five properties in hand, and let's say if I have 1 million cash in my bank accounts, what do I want? I may create a trust. It can be a few testamentary trust in a will. The first trust that I can think of is I may want to appoint a trustee or a trust corporation to manage my assets. I can set some milestone, like I want to bequeath a gift to my niece, but first thing that she has to fulfill when she attains the age of 18 years old, and she has to graduate from a university with certain degree. I may want to bequeath 100,000 to her if she attains 18 years old and she obtained a degree from university with law. So that is part of the trust that I can plan. Second thing, I want to trust that I want my trustee to hold until a certain extent. I may want him to hold the estate until my son attains the age of 30. That is another trust that I can plan. Certain things that when I have a property, I may not want my property to be sold in a short period of time. Or if let's say I have a piece of land, my land is actually generating income. So I may put in a trust. I may want my trustee to hold the land as a trustee for the benefit of my beneficiary for 10 years. 10 years after my demise. So the 10 years time, all the income generating will goes into the trust fund, which is held by the trustee, and that can be distributed 10 years after my demise. So that is another way that along the way, my beneficiary, they can actually entitle to the assets, to the money from time to time during the trust period. So there are many milestones that can be set. So I see this kind of trust can also be used in a succession planning. So for our heirs, for our beneficiaries. So at one point in time, I will only designate what are the estimated expenses that I need for my son to grow, for my son to be in the education fund, and for a portion of money that my son may need during his wedding, and a portion of money that my son will need when he attains the age of 30, at the age of 40. So these are a series of succession planning that can be done by a creation of a trust under the will. So I also see some other articles which are quite interesting from a will writing company, also in the DH market. I think the example is quite interesting. I'm not too sure whether it's a true fact, but I think can share here is very interesting insight posted by one of the will writing company in the edge market. The testator has two sons, but both are working overseas and never has the intention to return to Malaysia. So when the testator make a will, he actually distribute the assets equally to these two sons. Then after all, he found that he feels sad because the sons could never has intention to come back to Malaysia, and they may not going to meet after the demise of the disease. So thereafter, he changed his mind. He wants to create a testamentary trust in the will. What he did is he actually has a few houses and some cash in the bank's account. I think there's quite major assets that the deceased have in hand. So the deceased has thereafter created a testamentary trust that first thing, they appoint a trust corporation. So they would like to bequeath some of the portion of the money to be make donations to the charities that are designated by the deceased. Then the second thing, they impose the conditions that the house cannot be sold within 5 years. Then the third thing, they have imposed a trust. They created a trust that the two sons has to come back to Malaysia every 3 years or every 5 years. They will have to have a reunion dinner by fostering the relationship of two families. That is one of the part that has been included. Then thereafter, during the reunion dinner, if let's say they have met this requirement, the trustee is under the trust, they are entitled to release the fund, like 1 million to each of the beneficiaries. So that's where is a planning. Sometimes when it comes to succession planning, there is not purely on cash basis, not purely on properties, but it can be the testator has right to actually input some sentimental value, what he actually wishes the family to be together after the demise of the deceased. So that is another point where the testator can consider to create a testamentary trust under the will. And I see the trend now, they do have some living trusts. Declaration of trust is emerging in Malaysia. But although living trust, declaration of trust, there is no specific law under Malaysia to govern all this. But living trust can be created during a lifetime of the testator. There is another pros and cons for the preservation of assets and prevention of assets against creditors. And I do see other trust foundation has been also implemented. There are Labuan Trust, Labuan Foundations, the corporate body with separate legal entity to manage the wealth and to manage the property for lawful purpose. That can be charitable and non-charitable. So there are many ways in the succession planning. So if anyone has is interested in doing a succession planning, I think it is important that you can plan earlier and you have engaged your estate succession planner in assisting you to do a proper succession planning in Malaysia. Yeah. I hope I answered the questions. Yeah, a bit lengthy. The next one, please.
Okay, so let's continue to the following questions posted by Ken Howe. Do we need an executor to execute a will to the beneficiary? If yes, the executor entitles to charge fees?
The answer is yes. It is mandatory to have an executor to be appointed in your will. And an executor entitled to charge fees unless this is specifically spelled out in the will. Otherwise, it will follow our Probate and Administration Act. It is under Section 43 sub 1 that we say they can apply for the prescribed law is 5% from the total assets. But however, it's discretionary upon the court's discretion. You can put in these applications during the application for grant of probate later.
Okay, so question 4. Who is legitimate will writer, i.e. lawyer, insurance company? We write our own will writer company.
Interesting. Legitimate will writer. There is no specific law governing who are the legitimate will writer. As long as the will fulfill all the formalities, it is written by. You can write your own will, definitely, but as long as it fulfill all the formalities under the Wills Act in order to constitute a valid and legal will, be it the will is written by lawyer, insurance company, or your own self, that is okay. But to my point of view, the purpose of writing a will is to make your wishes and to make things certain. So make sure when you are drafting a will, it is compliant with the formalities to be witnessed by two witnesses. and make sure the will does carry all your wishes. Otherwise, it defeats the purpose of writing a will. So if you have any special arrangement or specific arrangement that you want to put under your will, it's better to engage professionals. It can be a lawyer, it can be a will writing company to customize a will for you. Yeah.
Okay, so another two questions from Ho Chi. Full process and documentation in respect of transfer of shares from deceased via will and the stamp duty payable.
Full process and documentation transfer of shares. I assume this is referring to property, right? If transfer of shares by way of property, that will be under the slides that I've shown, very last one. Basically, that is the process for transmission and transfer. The process would be after you get your grant of probate or after you get a grant of LA with distribution order, then we will assist you to prepare the transmission form to transfer the property to be vested under the name of executor or administrator. So once this is transferred, then we will thereafter submit the form of transfer for the property to be transferred to the beneficiary. So that's the process. If you'd like to know further, you may email to our general email. We can provide you the full process and the documentation. But bear in mind, different states have different prescribed forms for the transmission. So it has ultimately has looked at where is your property being located. Yeah. The next one, oh sorry, I missed the question. Stamp duty payable. Stamp duty for the transfer and transmission is only nominal 10 ringgit. Unlike those normal transfer, they will require the ad valorem stamp duty. But for the transmission and transfer, it's only 10 ringgit under the Stamp Act.
Okay, for question 7, posted by Michelle Tan, when is the first beneficiaries meeting after the probate has been granted?
First beneficiaries meeting after the probate. There is no such requirements or mandatory requirements imposed on under the law for the executor to carry out a first beneficiary meeting. So there is no law governing this. One thing is that when you are appointing a responsible executor, depending on how proactive the executor, they will initiate a meeting after the grant of probate for further discussion, but there is no law governing this.
Okay, question 8. Is there any time frame that can challenge the will and probate?
Time frame to challenge the will and probate. So assuming the will and probate has yet to be granted, is it? If let's say the will and probate has yet to be granted, there is no specific time frame prescribed under the law to challenge the will. So I would suggest that the beneficiary or any interested person challenge the will before the probate is granted. If let's say the way they can do is, let's say after the deceased has passed away, the beneficiaries or interested person can immediately file a caveat in the High Court. There are caveats for the restrictions in order for any interested person to take the grant. So you can immediately file a caveat under Order 71 of the Act. If let's say the probate has already been granted, you would like to challenge the probate, it has to be done as soon as it's possible before the distribution and dissipation of the probate, dissipation of the assets. So time frame, I doubt whether it is governed under Limitation Act, but it has to be done as soon as possible before the assets being distributed or dissipated. Next question.
Okay, so for the next question, for beneficiaries who landed property, will the transfer be subjected to any tax, inheritance tax, for example, from Xiong Yun Ma?
As far as I know, there is no inheritance tax be subjected to the person who inherit the premises. The inheritance tax, I believe this has been repealed quite some time ago. So as of now, there is no inheritance tax for the beneficiaries to inherit a landed property. Sorry, due to the time constraint, there are a few questions which I see here. I may answer a few questions before the end of the sessions. I see there's a question here. If the beneficiary and the executor is the same person, can the property or title be registered directly to the beneficiary instead of to the executor? So yeah, the question is, if let's say beneficiary and executor are referring to the same person, can we actually transfer the property to be registered directly to the beneficiary and not going through the executor since they are the same person? So my answer to this is it cannot be done. It has to follow the procedures. If you see my very last chart, the transmission and transfer, it can be done together in certain states in Malaysia, but not every state. So it depending on where the land is situated, and also it depending on the practice of the land office. But if let's say for Selangor, we can actually do it together. We can actually submit the transmission and transfer together. So there will only be one-time process. But according to the law, the process has to be transmit to your executor, and then from the executor, we have to transfer to the beneficiary. It's a two different process. Yeah. So, please, any more questions?
Okay, so for the remaining questions, answer via email due to the constraint of time. So before we end this session, kindly be informed that an evaluation form will be sent to you all via email, and we look forward to your feedback on our webinar today. I believe that's all the time we have today. This marks the end of our webinar. Thank you all very much for joining us.
Thank you very much for everyone. Thanks for your time in joining us in these sessions. If you have any more questions, you can feel free to send to our general email. We will reply to you one by one. Thanks everyone. I hope you find it informative. Anything that you would like to share with me, feel free to keep us posted. Thank you.
Thank you very much.